thank you, everybody. I'm glad that we're able to meet here today. I just want to give everyone a bit of a background to why we're putting this up. There's a lot of conjecture out there at the moment, misinformation and things like that. And we just want to clarify certain things, because now that the provisional liquidation has been granted, there are steps that need to be taken to be able to recover the actual assets. And I thought the best way to do that is for you to speak to the type of people that will be doing this work, and the solicitors and advocates in the background who will also be managing and looking after the process. And there are a lot of questions that our investors have that we are going to try and cover the sort of main points this afternoon. So we have here, we have a panel of experts, and Advocate van Staden, Hendrik van Staden, who was consulting with the RAG team over this lovely Christmas period, which we managed to give up on the 24th, has agreed to bring these people to the table as well, so that we can talk to them and find out what the process is, and to try and get everybody, all of us collectively, to make the right decision, so that we give the right people adequate opportunity to recover the funds. So I'm going to hand over to Advocate van Staden now. The other panelists here are Thijs and Sharon, and I was hoping Henry, and also I see that William is here as well. These are RAG members and have been working on this whole project with us throughout. Unfortunately, Henry might be in a difficult position at the moment because he doesn't have very good internet where he is right now, but he might be popping in and out as we go along. So I'm going to hand over to Advocate van Staden, who will introduce the panelists who are going to answer our questions.
Good evening, everyone. I'm Advocate Hendrik van Staden. I'm one of the advocates who is in drafting of the liquidation application in the High Court, which was granted today. Just a little bit background of myself. I started in the legal fraternity in 2014, where I used to be a legal advisor as well as a prosecutor at some stage. And then I did my pupillage in 2016, when I became an advocate under Advocate Karel van Heerden. I am a member of the National Bar Council of South Africa. I did write the bar exams, and I'm specializing more in mining, and I'm doing a lot of community work as well, especially opposition against exploration and mining near areas such as Doringpoort. And I also assisted the Roodeplaat community in doing representations with regards to the problem at that site before the Human Rights Commission. Also, I have Ponzi scheme experience, having been through and busy with voltage solutions of Mr. Willie Breed, as well as investigation into BTC Global. Except for that, I'm also assisting various law enforcement agencies in investigations, criminal investigations. And I'm here to talk about our application tonight and also to introduce the panel. If we can start with our expert, liquidation expert, as Mr. Christopher Roos. He's a director at Liquidation Experts and liquidation experienced liquidator. Christopher, if you can just ask to introduce yourself, please.
Okay. Hi, everyone. My name is Christopher Roos. I'm an insolvency practitioner. I've been in the insolvency industry from about 2002, so I've got a lot of experience in terms of insolvencies, liquidation, sequestrations, business rescue, tracking and tracing of assets, insolvency inquiries, all of that kind of stuff. So we've done also huge cases, so I already know where to go with this case in any event. Later on, we'll just discuss the way forward in terms of how everything works, that the members and investors fully understand the process. But further than that, yeah, that's all I specialize in, liquidations.
Okay, thank you, Christopher. The second expert that we've got on our panel tonight is Zain Dippenaar. He's an experienced auctioneer. Evening, Zain, can you just introduce yourself to everyone listening?
Good afternoon, ladies and gents. My name is Zeno van Christe Dippenaar. I've been in the insolvency industry since 1995 when I established the company. I've been through various liquidations, thousands and thousands, insolvent estates. And in that also I was commissioned by the AFU, the Asset Forfeiture Unit of South Africa, where we work closely with the NPA, the National Prosecuting Agency, where we did a lot of apprehensions of people that contravened the Organised Crime Act. And I've been very involved with that in so far that I've got vast experience, and I am currently involved in 2 Ponzi schemes where we're tracking assets with liquidators. So I would say I've got a lot of experience in this field.
Okay. Thank you, Zen. And then our last expert is Advocate Vaughan Victor, my colleague, who also drafted an application in the Cape Town High Court, and is also very experienced with Ponzi schemes as well as cryptocurrencies. Vaughan, if you can introduce yourself to everyone listening, please.
Good day, I'm Advocate Vaughan Victor. I specialize in cybersecurity, cyber law, as well as cryptocurrencies. I've assisted in numerous investigations and liquidators investigating especially cryptocurrency Ponzi schemes, BitLab Network, Voltage Solutions, and BTC Global. Secondly, I do a lot of work for government organization, especially the African Union, in terms of cyber legislation, where I'm currently assisting the United Nations Drugs and Crimes Office with the drafting of the Malawian legislation on cybercrimes. I'm also an insolvency practitioner on the master's list of insolvency practitioners, but I only do it for the investigative purposes. I do not take appointments to be appointed as such. And yeah, that's it.
Thank you, Vaughan. If I can also just give a small background of the application that was brought today, because there was a lot of questions on why our application was initially opposed by RAG, which is working in the best interest of various of the investors in MTI. Initially, we brought the application last week to have MTI provisionally liquidated. So we were opposed by the advocate from RAG, Advocate Toby Benari, who was taking instructions from them. The reason why they opposed it was to just take a look that if provisional liquidation is the best way to go to ensure that investors' assets are able to be protected, and it will be in their best interest. After a long discussion this weekend and after a lot of meetings between the various parties, it was decided that it was in the best interest of all the investors that MTI is provisionally liquidated, just to protect the assets that's in MTI and the assets that they are holding on behalf of the investors. So that is what led to the granting of the application this morning. The applicant was Mr. Anton Lee. He's residing there in Pangeni, in KwaZulu-Natal. The attorneys that was the correspondence here in Cape Town is Vezi de Beer, and the attorney that appeared was Yassim. It was myself and Advocate Vaughan Victor that drafted the application and the notice of motion. And the advocate that appeared in the High Court this morning and on behalf of us in the case is Advocate Hollander. And as we said, it was in the best interest that a provisional liquidation was granted, so that the assets that's being held by MTI can be protected from being shipped off to third parties who's not entitled to it. Thank you, Chris.
Okay, I think just one thing we need to clarify as well, by doing the provisional liquidation, all the interests of the parties are protected. It's not a question of the applicant's interests are protected. And that's why no additional applications were needed, and all the advocates that were representing different parties could actually piggyback on one application because everybody agreed that was fine. If anybody had disagreed, they should have stood up in court, say, I'm here because I disagree. And I believe that that's why there was consensus. Is that correct? Am I interpreting that correctly?
Yes, Chris, you are interpreting it correctly. So now the application is granted, it's a whole process that will go ahead, which is the appointment of interim liquidator. But our panel of experts will go through that and explain it. But also like to make everyone attentive. There's a lot of false information out there, and people claiming that they were the attorney firms whose application were granted in the High Court this morning. So if it is not Bessie de Beer, then the attorney firms claiming as such is not telling the truth. Unfortunately, it would see in the media that some of the media houses were also incorrectly portraying it that it was another attorney firm in Rondebosch in Cape Town that were granted the interim order, which was not the case.
Okay. All right. Would you like to just brief the process so that we can tell the investors how this process will run? But I think the most important thing that everybody needs to take away from this is where this morning before the application, we had no means of recovering these funds. Now we have the tools to work through this. And I think the important thing that everybody needs to also understand is that if MTI step up to the plate and say, here are the assets, and it makes it liquid and they can be distributed equally and fairly across everybody, then the liquidation can go away. The reason this provisional liquidation was granted was because MTI couldn't step up to the plate and say, here is everything, here's the funds that are needed. Please guys, just work with us, let's get this sorted. Was there any presentation from MTI in court this morning? Just as a question, may we ask that question?
No, there was not, Chris.
Okay.
And as you correctly said, there was an act of insolvency that was committed. Our client, Mr. Anton Lee, attempted to withdraw his money on the 1st of December. He put in his claim. By the 3rd of December, when his money was not made available within 48 hours as what used to be, then he decided to go through the internal procedures with MTI, and he was unsuccessful to get his payout. And that's when he approached the legal team to assist him. And that's what led us to the application. If Mr. Johan Steinberg would have appeared and told all the people that wanted to withdraw their assets that are entrusted to MTI, and he is able to pay it, then there would have not been any problem. Because then it would mean that the company would have been solvent.
Yeah, but sorry,
yes.
but I think just to follow on that, and if he steps up to the plate now, and then this whole thing can be reversed as well, am I right?
That's correct, yes, Chris.
Okay, so we're inviting the gentleman and his managers to step up to the plate, and let's get this thing solved without having to take the course of action that we are now necessitated to take. Is that right?
Yes. That would be the best option and in the best interest of all the investors. And it will be much more cheaper, if you can call it like that, the process.
Yeah.
But if I can ask that we can hand over to Zen to just give us a brief background of the whole process. Zen?
In a nutshell now, that the application's been granted, we have to get a liquidator appointed, and that in itself is another story now. There's a lot of things that has to happen now, and that is up to each MTI member to bring his side. Now, this is like an election in your country, where you have to elect the right person for the right job here. And if you're going to elect the wrong person for the job here, you will feel the effects of this afterwards. So it's very important that you elect the right person. Our company's got a national footprint right through South Africa. We are based in KwaZulu-Natal, Garden Route, Cape Town, and in Gauteng. So we work with all the liquidators, and I can't tell you today who the right and the wrong liquidators is, but I can give you the guidelines in this specific. So first of all, we have to get a liquidator appointed. That will go by the requisition or nomination system. After the liquidator is appointed, they will have to issue a bond of security for security of the assets and the value of the assets. And from there on, the liquidator will then start to process to see how much of the assets he can retrieve and look after in the provisional application. to make sure he finds as much asset as possible and see if the MTI top structure and Mr. Jan Steenkamp don't want to come to the party and come and divulge where all the assets is. That will be first price. And I think from here on, Christopher can just tell us exactly how the master will have appointed. I will back him up if I see he leaves something out. But I think it's very important to members to know how the liquidator is appointed, what they must do to fill their requisition forms in, where these requisition forms must go, how the master of the higher court will then act on these requisitions, how he will appoint the liquidator in this case with those requisitions, and then after the appointment has been made, what the plight of the liquidator will be immediately to the investors and to the members of MTI. Christopher, I think you can take it from here. If I leave anything out, I will interrupt you on that point. I'm sorry, but otherwise you're going to go by the waypoint there.
Yeah. Okay. So firstly, all the creditors must lodge a nomination form. It's not a must, but if they don't lodge a nomination form, we don't know who they are. From there on, they must nominate at least 2 names that I think are the preferred liquidators take on this, as they have experience in this.
Christopher,
yes.
Christopher,
sorry, you.
I think what you should do, Christopher, is you can switch off your video. That will help your wave band. And we've seen your face. We know who you are now. So, and if you could just go back a little bit, Zen, you were saying.
Yeah, Christopher, we lost you there. You have to start at the nomination form where the member or the stakeholders can fill in this nomination form. It's not a must, but we prescribe it. It should be like that. Okay, go ahead.
Okay. So nomination form, there is no cost involved to that. It's a form that the creditor or member or investor must complete, stating their name, their full names, address, email address, telephone numbers, and then it must be in a rand value. So you can't say in US $1,000 US. So you and must that into words and numbers. Underneath you will see you must sign there, put your full names there, and also mark in terms of what capacity. That will be other and as in investor. So a liquidator is appointed based on value and number. So value, if I get a nomination of 20 million rand, then I would have the most value. But if another liquidator gets 100 appointments, people with 1,000 rand, or 5,000 rand, or $2,000, he or she then will be appointed on numbers. The master also has other way of appointing liquidators, which add other liquidators, and that we call previously disadvantaged individual, which is mostly women, African male, female, and other people in our country. But that's just a system base. The other thing that's very important is as soon as liquidator is appointed, he or she must act swiftly, go and take control of the assets, check everything, and from there on start with the legal investigation, and if necessary, or in this case it will be bring the necessary court applications. Later on, company doesn't have to be finally liquidated, but in the process, you can have insolvency inquiries, you can do investigations, you can call people up as witnesses, you can also get a warrant, search and seizure warrants to go and search for the stuff. So if the people don't comply, obviously that will be a criminal case against them. And the most important thing is to get as much money back as possible. The sooner a liquidator is appointed and the correct liquidator, the sooner he or she can act, and then from there on report back to the creditor. So a liquidator, his work is to secure the assets, liquidate the assets, and then report to the creditors. And he or she must act in the best interest of all the creditors. So that's very important, is to get the correct to do the work, and also that understand cybercrime experts, forensic investigators, everything like that. So we've got a backing with Mr. Zen, the 2 advocates, everything to go after this. That won't be a problem. Yeah, so just quickly, after this whole process is done, obviously depending on how much money has been retrieved or recouped, it will also depend, this maybe stop me if I'm incorrect, but the payments that was made to other people, they can also be reput and brought back to MTI. And from there on, there's a first and a second meeting of creditors where creditors can then lodge a claim. That claim was then shown they put an X amount of Bitcoin or money into MTI, and that will be then approved on a first or second meeting of creditors. And once all the money is received and the liquidation is finalized, everything, we must then draft the liquidation and distribution account and then pay out the creditors. But I've read a lot of stuff in terms of case law, so I think it's going to be something different here. But a lot of people are asking, can we pay it over in Bitcoin? I don't think it will be happening in that way. We must pay it over cash or EFT to the creditors who lodge a claim. So if a creditor doesn't lodge a claim, he or she will not get any money.
Okay, sorry, just an immediate question here. Zen, is there anything there you'd like to clarify before I throw this question?
Yeah, Chris, I think just to back Christopher up on there, just to questions that we've been seeing on the groups that to me has become a focal problem point for the people is the first thing they're asking, can we fill in 2 forms for a liquidator? That is not acceptable. If you fill in 2 forms for 2 different liquidators, the master will disregard both those forms. So only fill in 1 form for a specific liquidator. In that respect, I can tell you as an auctioneer that's been doing this for 25 years, how do you choose a liquidator? That is a difficult situation for investor, as he's never dealt with this.
Yeah.
10 to 1, somebody internationally doesn't even know this kind of law exists somewhere. So this makes it very difficult for them. So I would suggest if I was in their shoes, there's currently 5 liquidators doing the rounds on the circuit of the groups and everything. I would go to their websites as a person standing neutral in this, because all these liquidators are clients of mine. So go and read up on the websites what experience these liquidators have, and make sure that these liquidators have experience in both Ponzi and pyramid schemes, as well as in the wallets of the Bitcoin and the Bitcoin as such. It's no use they've got no cryptocurrency experience. It's no use they don't have any pyramid scheme experience. I would say 70% of all liquidators in South Africa do have pyramid scheme experience, but I would say I would narrow it down to maybe 2 or 3% of the liquidators having Bitcoin or cryptocurrency experience. So make sure you back somebody that's got that experience, because people, it's a learning school. If you have to learn cryptocurrency, the people on this panel that invested, you know, in the beginning when you had to invest in the cryptocurrency, it was a learning school. You might have lost money in your first investments and made mistakes. You don't want the liquidator to go and make mistakes with your money now, because he doesn't know what he's doing. So make sure the liquidator that you back, you've checked him out, he's got the experience in this. Otherwise, you're going to pay for his school fees, and I don't think you want to do that. That is an important fact to me. And then on the other issues that I've dealt with a lot in my career as an insolvency auctioneer is your liquidator mustn't be scared. Sometimes there's influences from the other side that can pertain to him being scared. You must choose a liquidator that's not scared. He must be able to operate anywhere, any place. And remember, here we're dealing with international clients here. It's all over the world, and all the countries don't have cross-border insolvencies. And especially with people like SARS, your liquidator is going to have to stand up for you there, go and fight for you there in SARS, because obviously SARS, the money didn't come into the country. So SARS is going to be a problem, and your liquidator can solve it if he's got up to it and a strong liquidator. So that is very important. By choosing your liquidator, make sure you choose the right guy. All this is superficial. All we've done so far, taking control, doing what we had to do, is superficial unless we choose the right man for the job here. That's all I want to say, and that's very important. We must take this to heart.
I think from what we've seen, there's a massive big contingent of people who are offshore, in other words, outside the boundaries of South Africa. From what we're seeing on the internet and the reactions that we're getting. I mean, yesterday alone, we were up to 300,000 hits on the website. And last night when I was working, we had more than 38% of those people just from America alone. And at the moment, the whole of the website, the whole statistics on the website is less than 50% is South African. The rest is international. So there is an international question here, and that is, if you are outside South Africa, you can still fill in that form. Is that correct? And still appoint your liquidator and submit your application in Rand. Do you have to submit your application in Rand?
Yeah,
So you
what
have
I
to-
suggested, maybe also, sorry, from my side is you can fill it in as dollars and /rand. But that
Okay.
will, because if you, just from our side and our experience, if you take the dollar, the pound, and other currencies and you put that into the master's office in their hands, they're not going to understand fully how to evaluate the situation. Who has number, who has value, or Zimbabwe dollars, that can be $1 billion. So it's going to be a mess. They only understand South Africa rands. So the people have to take their Bitcoin, convert it to a rand value or dollar value, and then convert it again. I'll just share the links with you, which I sent out to all the other creditors that contacted me. There's a converter for them that they can use and say, listen, this is the amount, and here's the rand or dollar value. And it also, because I must write it down in words also, they can just click and paste it, and it writes everything for them there. Later on, we can obviously work out in terms of, but it's going to be difficult. I must say today, MTI is owing me so much, and that we must work on that.
Okay, another question that comes up immediately, and I'm just throwing this open to the panel. I'm now an overseas investor, or I'm a South African investor. Do I need to go and get myself, pay a lawyer to get this, to get this done? Do I need to get a lawyer to check up on the liquidator? Do I need to spend money now? Or is it okay for me just to say, okay, go and fill in the application. All those papers that are filled in will be collected by the liquidator, I assume will be collected by the liquidator who has been awarded. And I would, from my just layman's knowledge, know you can still submit that application if you think yours hasn't been submitted. So in other words, I filled it in, I wanted Joe Bloggs to do it. Joe Bloggs was not appointed, Peter was appointed. I don't know if Peter's got it, so I can say, look, here's a copy of what I filled in. Please make sure you have this on record. I can do that, right?
You can do that. That's 100%.
Okay, but I mustn't fill in two, right? You're going to get me.
If you fill in the two liquidators form with exactly the same stuff, it's null and void.
Yeah.
We've also experienced it. I just quickly want to come back to that. A lot of people run to attorneys. At the end of the day, the company is in provisional liquidation. A liquidator is appointed, and he and she must take control. It doesn't help you go. The forms are simple. To go and pay thousands of rands, the process is the process. There is nothing else. There's nothing at the background going on. There's a process that must be followed. The master of the High Court is there to make sure the liquidator does his job. The creditors can also follow up and say, listen here, what's going on? I just want to say, if I was appointed as a liquidator, I would start immediately a blog with the RAG team, integrate my systems with them, issue monthly letters stating what's going on, what we've already done, and what's the process forward. Because it's easier to communicate in that way instead of getting 30 or 40 or 50,000 emails or quotes a day. So, just to get that platforms out and people can go onto that and read what's going on. Okay. That will be a lot easier.
Okay. All right. I think that covers it a bit. Is there any, can I say, is there anybody who's got, would you like to, just before we wrap that up, does everybody on the panel believe we've explained this situation well enough for the person to understand what the process is? I think there are two very glaring outstanding issues here. Are you going to get my money back for me? And number two is, how long is it going to take? Look, I think you are going to get money back. We still don't know how much you're going to get back. I think that's the real answer. But please don't go and find a tree to hang yourself from. It's not that bad. There is a massive opportunity here. And we might not get all of it back, but it is growing while it's still Bitcoin, which is really, really good news, to be honest. But also, we might even get all of it back. You're saying that the assets you reclaim immediately, the ones the easy pickings are there. They are going to be found, but there are also, you can also roll this back and say, dear Mr. Wine, why did you get so much money?
Yeah.
This is not fair. You need to
Yeah.
give us that property back, because that does not belong to you.
That's what we call collusion. So in transactions 2 years and back, a liquidator can cancel. So if you demand the money back and they don't pay, then you can take a legal course. The only way to knock them is to bring a sequestration application, get access to the bank account, get access to the Bitcoin, sell all their stuff. So they've got either a choice. They can either work with us or against us. But to work against a liquidator, it won't help you. It's not gonna, you're not gonna get very far.
Chris, just to bring you up to speed here, one of the Ponzi schemes I done, just to give you a rough idea, we had 9,000 investors on one scheme there, and we literally had to bring back 980 of that people's money back into the scheme, of which I think we roughly sequestrated about 200 of them in the end to get all the money back. It's not a nice thing to do, but those people are actually sitting with the other investors' money at the end of the day. So the liquidator will act swift onto those people very, very soon if they see that. So the fat cats that took the money and was eating out of it, they're going to have a bit of a problem here, because there's a lot of people out there that has really lost all their money and their life savings and everything. And to me, this is one of the reasons I do these schemes. I don't like that, and I will go for them, I promise you. We won't take that nonsense. And I'm sure Christopher, whoever the liquidator is, will not take that nonsense, because that is where the whole problem started with the scheme.
Okay, I want to give Tace a chance. He's been holding up his hand and being very tolerant there, Tace.
I just would like to, it's actually about time frames, just 2 time frames. This provisional liquidation period, is there a certain amount of days that this company will be under that order, and then that can change? That's my first time frame that I would like to ask. And then secondly, the time frame to appoint a liquidator. Do we need to act now as quickly as possible to get a liquidator appointed?
Yes.
Or do we have a certain amount of days? Or
yeah, I'll quickly explain to you. So the first one on that court order, it says the company is placed under provisional liquidation, and within 30 days, Born or Hendrik, you must just tell me the date. I can't remember it now.
1st
will
of
then
March.
go back to,
1st of March.
1st of March. Okay, they will then go back to the court and get the final court order. In the meantime, because the court order is already there, obviously all the liquidators are getting their stuff ready. They're going to lodge all their stuff. So within the next, I would say 48 hours at the most, you must have your nomination form at the liquidators. You can scan and mail it to them. I think most of them, when I send it out, I also attach examples for them to just show them this is how you must complete it. And then later on, you know, we get to the process. In terms of the other process, you know, that will all depend on, is it cross-border, how long it will take to get the stuff here, how long it will take the first, second meeting to verify, you know, all the investors, all those kind of stuff. So that will be another mission, but we've got a group of people that's highly experienced. I don't think we will have a problem there. So just one thing that I thought about, and which I also read on the other currencies, is the day that let's say we get the Bitcoins back today, okay? So it's worth, what's Bitcoin now? $24,000. Sorry, what's the Bitcoin price now?
I don't know.
Okay.
Last I looked, it was in the 20s.
27.
Yeah. Okay. Yeah. So my only problem that it's maybe a good thing and a bad thing. It's now $26,566 for one Bitcoin. But let's say it goes to 32. That's fine. There's more money in the pot. But if it falls back to 10,000, obviously, you know, there's going to be a loss. So the day that the liquidator gets that money in, there must be a decision made and say, okay, are we going to cash it up and put the money into an interest-bearing account or keep it there? That's a very tricky situation for a liquidator. because you must act in the best interest of the creditors. I mean, it's not like it's like the stock market. You never know what's going to happen tomorrow. So that will be, for me, if I was appointed, a factor to get that done.
Yeah, we can just pray that it keeps going up. Okay. Is there? Are there any clearing questions? Thijs, are you comfortable? Are you? Has that answered your question?
Thank you
Thijs,
very
was your
much.
question answered with the time frame to get the appointment of the liquidator for 48 hours? So we should have an appointment by Thursday afternoon. If there's too many administration, too many nominations, it might stand over till Friday, because you can imagine if there's 50 or 60,000 nominations going to land up in the master's office on the table, it's going to take them time to sort that out. So we might run over to Friday.
The practical questions here, because I'm not in South Africa, so that's a problem. In the UK, I can post the letter this afternoon, and you will have it on your desk tomorrow. How do I get it to you? Or do I fill it in and fax it to you? Do I fill in
Email?
Email. I can do it email, so I can
Yeah.
send you an email. All right, so great. Okay, so we take a form, we download a form somewhere off a website which has got your name and stuff on, and then it's got a couple of blocks. What's my email address? How much am I claiming? And what would be the other block? And I appoint you signature, that thing, and then I scan that or take a photograph with my phone. Yeah, that'll work, wouldn't it? And I send you that photograph that comes off my phone. That'll work as well. I can email that to you, can't I?
Just be clear and visible, and I just rather suggest is if they take a phone, they mustn't hold the phone like this and take a picture that side. They must hold the phone over like this, because we get a lot of photos, then it looks different. It's like at the angle. So if they take it with the phone, like there's also a scanner app or whatever, then you can take a clear picture, but it must be like, in that time of the frame of the picture.
Okay, now
so it comes out this, it's difficult to read what's going on there.
Now I have a problem. I don't have a printer. What am I going to do? I don't have a printer.
Yeah, well, you can. Well, my one recommendation.
Can I handwrite it?
Yeah, you can handwrite it. Okay, but you don't. Let's say you don't have a printer. Okay, my form is in a PDF Word format. So if a person has a smart tablet or whatever, tablet or phone or a laptop, they can type it in and then just sign it on that document, or copy and paste their signature on the document. That's also
can I
fine.
type it into my email and send it to you and say you can send me a verification for a signature or something like that? Is that possible? Or does it there have to be a signature which can be read?
Yeah, unfortunately, our insolvency staff here at the master's office hasn't at that point where you sign everything electronically. It's not adapted or evolved that way. So,
so please don't tell me you are going to destroy trees printing it all out to take to court, are you?
Yeah, I understand that fully. So, but unfortunately, master must have a copy. We must have a copy.
Okay.
And you want to check if the claims are legit or not. But that will be done on the first or second meeting of creditors, because you get people that take a chance. So, and just what I saw on the other questions, on the ones that you sent to me, I see other people also worry about that. If a liquidator is appointed, he or she must take out a bond of security. So normally there's 2 or 3 liquidators appointed on big cases. And in this case, like all the other cases, they must sign everything together. So the payments, everybody must verify that the same is correct. But there is insurance, and like this stuff is big. Obviously, you don't want trouble. We don't want to go to jail. So we just want to get for the creditors and pay it out. That's all. And secure. That's all. And then obviously go after the guys that mess around.
You had your hand up, Zen. Have you got something that you wanted to add? Something specific?
No. I think another point that Christopher should collaborate on is the fees that the liquidator charge. I see a lot of people are worried what the fees that the liquidator charge in such a matter. I think Christopher just collaborate the basic fees there.
Okay. So in terms of Section Act 24 of 1936, which is our Insolvency Act, clearly states that a liquidator can claim these 3 types of fees. On fixed property, it's 3%. On immovable property, it's 10%. Movable property is 10%. Any cash that you collect, let's say like debitors or money elsewhere or selling of assets, also 10%. If there's money in the bank and you transfer it from one bank account into the insolvent bank account, there's a 1% fee. So there's no upfront fees for anybody, any investor, nothing like that. And we work on, we get a fee based on what we get in.
Okay, Christopher, you just broke up there, so I'm just going to
Okay.
repeat what you said. On monies found in bank accounts and monies found by the liquidator and transferred to his account will be a 1% fee on that. And then on immovable property, it will be a 3%. And then on movable property, it will be 10%. And that's the basic 3 tiers of costs that the liquidator can get. And also these costs, the master regulates these costs. And when they draw up the account for the estate eventually, it will lie for 30 days at the master for any creditor to complain if he thinks those fees are exuberant or something is wrong there. So it's not a set in gold. So even here, if it's a very big estate like that, the master might reduce that cost at the end of the day, depending on how much work went into it. So it's not set in stone, this whole fees thing.
Okay, just a rough thing. Yeah, I know. I don't know if you can give me a positive answer at the moment, but the question is, you're going to recover this in Bitcoin. What is the percentage on Bitcoin? Do you know what it is, or is there is the master going to set a different rate here? What is your feeling?
Well, it's money that we collected from, let's say, other individuals that was transferred for them. So it will most probably be set at 10%.
Okay.
That will be the fee. I'm not going to lie to you and say 1%. I think it will be at 10%. That's what I think it's going to be worked out.
Okay. I think in the end, we just need to, we might have to highlight the critical points here, and I will summarize them just to make sure when we get there. But there are some other questions that still need to be answered. But in principle, just a question that I think will be very valid is, what is your feeling of recovery here? What is your feeling of what can be recovered here, knowing the background of what we're dealing with? There are 2 questions. I'll ask the second one after that. What do you feel, Zen and Christopher? What do you guys feel?
Chris, I would like to answer that. I think we should move down to our experts in recoveries, and that will be Hendrik van Staden, Advocate Hendrik van Staden, Advocate Von Victor.
Okay.
They are the experts in recovering this. I don't think Christopher will also, or the other liquidators will employ people like that specialize in those recoveries. So I think they should answer this question.
Okay, so we can ask that tomorrow then. That's fine. And from the court's perspective, what do you think? How many liquidators do you feel the master might need to appoint here?
Maximum number, value, and a PDI. So maybe 3, it can be up to 5 liquidators, but in my point of view, it's unnecessary.
We have 280,000 potential investors here.
Yeah, but at the end of the day, what normally happens is there is 1 or 2 of the bind liquidators that does all the administration, and they then handle and deal with all the creditors. So in any event, the liquidators also come together, they discuss the matters and the way forward, if there's legal action that must be taken, anything like that. They come together and they discuss it. There's also a report that is drafted that is sent to the creditors to say, listen, this is the assets and liabilities that we currently know of, and what happened in the company. And just one thing, in the liquidation, we have the powers to call up anyone that was involved and ask them what went on. But I think there's a lot of information already there and work done, so I don't think that will be a problem.
Okay.
Yeah, I just want to come in here as well, Chris. There is another thing that Christopher is not saying, that I've seen plenty in big cases like that where I was involved in. The master has also got discretion. So if the master thinks this case is too big, there's too many investors here and 2 liquidators won't reach out to them, he might use his discretion and appoint another firm on his discretion or her discretion, the master. So that can also happen when the master feels that the work burden will be too much on 2 liquidators to handle. There is discretion that the master holds.
Okay, great. Okay, I think that's more or less it. I don't know, Hendrik, is there anything else you think that we need to get a bit of clarity? And then I want to throw the questions open to the floor so that Thijs and Sharon, who are investors, can answer, and then we'll close with comments. So
Yes, I just like my colleague, Advocate Vaughan Victor, who specializes mostly in cybercrime and cryptocurrencies, and who I've worked together with for some time now, to just give us an indication. Because there's a lot of questions from a lot of investors. Is there a possibility to get back the Bitcoin? Vaughan?
Thank you, Hendrik. Let's first get the whole story off the floor that Bitcoin is not traceable. Remember, we live in a digital world. All digital workings leaves a trace behind. The first thing what we already started last week is to put wallet watches on certain individuals' wallets, including certain MTI individuals. So the big thing here is, firstly, we all know Bitcoin is actually a private and a public key. So the private keys at this stage, that's the most important thing we need to locate, and all the different wallet addresses has been locked. And we're busy with that. We did it in a previous scheme, me and Hendrik, that we're still busy currently working on. But we recovered about 580 coins that everybody laughed at us. Some of the best actuaries, forensic accountants that, but you could not. And we recovered about 560 Bitcoin in a question of 2 weeks. The thing is, it is possible. Nothing is impossible, especially with the day and age with all the technology that's available to us. Sometimes we will need to get involved with certain government agencies that can help us with certain, especially with cross-border jurisdictions, and to help us to recover those coins. So my personal opinion is, yes, it is possible to recover the coins and to get them back to the investors.
okay. You want to carry on your questions there, Hendrik?
No, that's all from my side, Chris. If I can give it back to you.
Okay. I think that that reiterates my point as well. It's not time to go look for the tree yet, guys. There's a lot of hope here, and as long as we appoint the right liquidator, we can open this cyber thing, open this thing up, and where you could go in and you can burn down the tree, or the office where all the files are. You can't do that in cyberspace. I mean, we whatever we do. I've been working in computers. I did a computer degree in 1982 when Olivetti's were the computers of the day, and I've been working in computers ever since. And it's very, very few times you can't recover data if you've actually even got scraps of things to work with. So I think that the question here is, we need people who are not going to be a bull in a china shop. That's what we need. We need forensic scientists. That's what we're after. Okay, I think we've covered most of the questions at this stage of the game. We're obviously going to get lots of questions come in. Please go to our website. I'm also going to throw this open to the floor. I'm going to give everybody an opportunity to ask a question, and then also just to say if they've got any concerns or anything that we can deal with. So if I start with you, Thijs, are you okay? Are you comfortable? Maybe unmute your mic and say you're okay, or just a thumbs up, no questions. How do you feel about it, Thijs?
Yeah, I'm fine. I think one of the questions was how the investors will be kept in the loop during this whole process. And I think Christopher answered that by mentioning his blog.
Yeah.
Is that,
no,
will that be a standard? Sorry.
Yeah, sorry. I had a discussion with Christopher about this before. He sent me back and he said he will give us a monthly report of where he is, and whether he posts that on his own blog or he gives that to RAG, we will do everything in our power to get that out to everybody if he gets the appointment. We don't know if he's going to get the appointment, but I think what I'm thinking, and I need to speak to the RAG team about this, I'm thinking we'll draw up a checklist and we'll ask the liquidators to assign and check that checklist, that it will ask them questions, and we'll put their checklists up and their names under the checklists so that people can decide who they want to go with. And then we'll also give the liquidators an opportunity to give us a PDF form from them, which we can put onto our site, and they'll be able to, the investors will be able to see that. And if they want to make outside choices, that's fine. If they want to go with the checklist that we've created for the liquidators to sign up on, because we are going to ask the liquidators that they are going to commit to giving us information on a monthly, not a weekly, on a monthly basis. I think that's fair. What do you think, Zen? Is that a good idea? What do you guys feel, Christopher?
Oh, well, in my personal opinion, it would be a lot easier if you do it that way, to keep all the investors in the loop and they know what's going on. Because it's difficult to answer 40,000 phone calls or send 40,000 emails to different recipients. So let's say from my side, a drag, you know, if I could get any information or we draft, say, listen, we're standing at this stage of the liquidation process, or, you know, this has already happened and this is what's maybe going to happen. A lot of the stuff, obviously, we can't talk about because it may be sub judice and import or in the process of something. So then we can't mention it, and, you know, that must first be done and over, and then we can talk about it, then that's fine. But that, I would suggest that's the best way. And then obviously just translate the stuff into, I say there's a lot of people that's Portuguese and Spanish speaking people, you know, but they can do it on Google Translate if they want to, just to see what's going on.
I think Christopher, what Chris actually meant is by putting the liquidators on the site, so they could verify themselves and stuff. I think, Chris, don't let RAG get involved in that. Let the people go and do their own investigation. Don't get involved in that.
That's fine.
That is let them decide who they want to use.
That's fine.
There is websites, they can go and read up on their liquidators, they can choose one. There's a whole panel of them. Let them choose their own thing, and then they can never come back to you and say, RAG, you said these 5 guys were the right guys, and now they're not. Then you put yourself in the trouble there.
No, I think that's a wise decision. I don't want to be the one being crucified because the liquidator didn't do his job. Zen, you're very wise. Very wise. Thank you for that. Thijs, are you comfortable? Are we good? Okay. All right. William, do you have any questions or anything you'd like to throw at the panel?
Thank you, Chris. I think one of the most applicable questions I have is, if you have to put in a claim for other people, how does that work? What I mean with other people, I'm talking about minors. A lot of people actually invested money for their 3-year-old kids and stuff like that. Then we also have the likes of pensioners, people who doesn't know how the Luna wallet work and stuff like that. And then the last one I know of is foreigners. I know some people that's helped the Zimbabweans, stuff like that. So can you just explain the process with regards to that?
Okay. Regarding the minor childs, the parents or guardians can sign a document. That's not a problem. Maybe just with an affidavit stating, I am the father of this X person with ID number or verification number, whatever the case may be, and you can just send it in like that. I don't think that will be scrutinized as such. In terms of the pensioners, the only way that you can sign it on their behalf is with a power of attorney. So in any event, they have to sign the power of attorney, so they can just as well sign the nomination form. That will maybe do a bit better, because at the end of the day, if I sign a nomination form on your behalf and you haven't appointed me or I don't have any authority, then it's fraud. And we don't want that confusion and problems for anybody. In terms of the foreigners, it will also be that they will have to, the workers on the farms, wherever the case may be, they will unfortunately have to sign the documents themselves.
Thank you. Thank you. Can I have another question, Chris?
Yeah, sure, go for it.
All right. I just want to say, so if you miss the cutoff with the 48 hours, does it mean that you lose your investment? And what happens to that investment?
Okay. So what happens is there's a first meeting of creditors. normally the liquidators also send everybody a list, say, listen, there's a first meeting of creditors. If you want to, you can go and lodge a claim. But normally the clients don't go to the master's office themselves and lodge a claim. They send the claim document to the liquidator, and we have people that go to the master's office on that day and they prove the claim. So there can be a first meeting of creditors, a second meeting of creditors. That's actually where you then get a report. I think section 402, which will show the assets and liabilities, what was currently in the estate, and the reason why the company was liquidated, what happened, all those kind of stuff is in the report. And it will also show then if you must lodge a claim or not. There may be in certain circumstances a special meeting where creditors can also have a chance to prove their claims. But I don't think there will be like 5 special meetings. Obviously, the sooner the meetings are held and we have all the information and the process can be finalized, the sooner the liquidation distribution account can be drafted and the money can be paid out. So we have had it in certain circumstances where creditors, wait a year or two and they don't lodge the documents. We've asked them 3 or 4 times. If we then submit the liquidation distribution account and gets confirmed, they don't get their money. They're in the out.
I think just another thing we should know is, I think the people are worried if they don't fill in the nominations that they are gone null and void. That is not the situation. Remember, the liquidator that's appointed by the High Court, Master of the High Court, has to act on the nice word we call in the insolvency industries concursus. That is the body of the creditors. So you are forming the body of the creditors. It doesn't matter what your investment was. And that is by law what the liquidator has to take in consideration when he's wrapping up or winding up this estate. He has to act in concursus. So it doesn't matter what happens, you will always have your claim just as long as you follow the course of the liquidation. Like Christopher says, there's no use the liquidation distribution account's been lodged with the master, and 1 year later you want to come prove your claim. That's not going to work. So it's best to stay on board of all of this and keep up on tracking it. But the liquidator has to take you in consideration. If you've nominated him, didn't nominate him, he has to act on your behalf. He's been appointed. That's the law, the insolvency law.
Okay, can I just ask a follow-on question, William? I'll come back to you on this, but there's an important point that just came up in my thoughts, and that is I'm now submitting my form, and today, tomorrow, or a week late, whatever, I submit my form to the liquidators that are going to be appointed or might have been appointed. Is it a good idea to add a screenshot of where the last position was when I had my account? Does that help you as well? Does that sort of, because we've been seeing on the platforms that the people must log in and take screenshots of their accounts. Is that useful for you as well, or should we just leave that until you call for it, or what do you think?
In my point of view, we don't really need it now. We just need what amount is owed to you by MTI, and that's all.
Okay. So
the rest of the stuff we can, like in a claim form where you lodge a claim, there's stating MTI owes me X amount. You attach all your documents, proof of that, you sign it, you commission it, and it gets lodged at the Master of the High Court. There, the liquidator can scrutinize a claim. So if they feel that the claim is wrong, obviously that will be checked with the database, all those kind of stuff, to see if that person is on the system, if that person is there.
Okay. Sorry.
So just one thing, and maybe just ask the investors or the members, was all the transactions done by Bitcoin, or was it done by maybe they paying in the money and they bought Bitcoin for them?
No, you couldn't participate unless you transferred Bitcoin. Is that correct, Sharon? The guys who've been with the system a long time, you could never participate unless you transferred Bitcoin. You had to go and buy your Bitcoin, and then you would transfer the Bitcoin in. So all the transactions are Bitcoin transactions, and everything was held in Bitcoin as well. Yes, Sharon, go for it.
I think it's important while we're discussing that to just question, when we fill out this amount on the form, and you stating we must fill it out in ZAR, we're putting the rand amount. If you're overseas, obviously put USD/ and put the rand amount. Is that the amount that the investor, like myself, for example, invested into the company day of joining? Because remember, we've had bonus payouts. There's, not to confuse everybody, but P1 bonuses, P2, weekly incomes, etc. Are we just saying the amount that MTI owns us is that initial amount that we invested?
Sharon, if I can maybe answer that question, only the initial investment capital.
Perfect, thank you.
What you put in. Secondly, if I can add to Christopher, for the investigative side and for court proceedings, it is of utmost importance that members log into their back offices, take screenshots of everything. The reason why I'm stating this, it happened with BTC Global. People said, yeah, we don't need it now. And when the site crashed, how can you then prove this is what I put in? This, you understand? So you need that extra proof. I know it's going to be a lot of paperwork and a lot of photos and screenshots, but it's for utmost importance to take that members take screenshots of their back offices with the members, everything. So we have those screenshots to correlate with requisitions and as such, because if the data MTI, mymti.com gets switched off, that server gets switched off, then how can an investor member then prove, listen, this is what I put in, this is my account details. So for my side, Hendrik's side, I think it is important that members log in and take screenshots of their back offices.
If I can just collaborate here, that's going to be very of utmost important that Vaughan just mentioned that, because remember, people, there's going to be a lot of new scamsters coming on here and saying, I've invested here. Okay, where's your proof? No, I've got no proof. I put money in here, my Bitcoin, and he's going to have a problem. So how must the liquidator vet it if we've got absolutely no proof? How's he going to vet those transactions that Bitcoin was transferred? How's he going to vet it? So everybody can just go and claim. Even me, if I didn't invest, I can just go and claim. So that's going to be a problem. I think Vaughan is very absolutely right. And you must warn the RAG members to take screenshots of the back office.
Yeah, I would add to that, use your mobile phone while you're doing it as well, and take a video of what you're actually doing. You can take a video and take screenshots simultaneously. And then afterwards, bringing those two together is really good proof. You won't fake both of them in unison. It's not going to work. Okay, I think that's...
If I can just add, please.
Yeah, sure.
It's very important what Vaughan said. And we must remember, it's not like previous old Ponzi schemes, like Creon and those, because in those days, there was no cryptocurrency involved. What we found out, like with the BTC Global Ponzi scheme, that back office got switched off by a certain person, meaning all the data got lost. So as said, it is the utmost importance. That's also why this kind of investigation is getting more specialized. It's not like in the olden days where a liquidator can maybe go and repossess a house or a car that's tangible. Bitcoin is seen as an asset, but it is there in cyberspace, if you can call it like that. It's not something that you can touch physically.
Okay. Okay, William, sorry, we all interrupted you there. Are you good? Are you happy? Have you got any more questions?
Yeah, I don't know if my questions are applicable 100% to this forum, but I'm just, I haven't been scammed in a while, but I have been scammed before. I'm just curious as to how is it possible that the website is still on after approximately a month or whatever weeks later. So just curious about that.
I think there's an obligation, there's a very clear obligation on the people running the website not to be seen to collude with these people. And what they should be doing is to protect themselves, keep that website up and running as long as they possibly can, and protect that data with their lives. Because if that website is taken down, there could be collusion and they will be making themselves liable to being things. Because somebody's going to come to them and say, listen, you knew you were running these servers, you knew the extent of what was going on here, and now you've taken it down. Where's the data? And you, that person immediately, doesn't matter where he is in the world, is liable because there's an international there is an international case here. Hendrik, have I done that correctly, or would you like to add to me and say I'm being stupid?
No, I totally agree with you, Chris. And you're 100% correct with what you said. I don't know if my colleague Vaughan would like to say something.
Vaughan? Vaughan,
Sorry,
you
okay, sorry. Can we? Sorry, this is gonna sound terrible. I didn't listen to what you just said. Could you please repeat that?
yeah, that's terrible, Vaughan.
No, I'm sorry.
Do
I'm
I always
receiving
bubble
so much.
like that? Hey, Vaughan.
No, I'm sorry. I'm sorry. I'm receiving so much information
Okay.
as we speak. You know,
Vaughan,
I've
you are
received like
forgiven.
100 minutes.
I know.
Yes,
I know. Normally, you are Farmer Brown, and it must be difficult to live up to your name today.
Sorry.
Okay, let me
can you-
tell you what I said. I said that, and I think it's good to repeat it as well. I said that whoever is in control of that server at the moment and that data has an obligation to keep it running. And if they allow that server or that data to get lost, they are colluding, and that could be very, very serious for them.
At this stage, the server host is not based in South Africa.
We know that.
Yes, and unfortunately, in the country that the server is hosted, those authorities you don't play with. There was an instance about 6 months ago with scammers that was not the same, but the parent company of the same company was hosting the service. They were scamming people in the UK, and after 20 IT people that was running those servers, about 5 of them received a death penalty. So,
oh my goodness.
Bad authorities in the country where the service currently hosted, they don't play around to these type of things. So, but in due course, in the future, it will be utmost important that the appointed liquidator will notify those authorities and state, listen, guys, you need to have a lockdown on the servers, and with a court order that they will please provide us with all the relevant information on those servers. So yeah, but at this stage, somebody said, yeah, but why haven't they switched off the server?
They won't.
That question is still baffling my mind as well. So, but like the previous messages and information I received, by the looks of it, some people didn't pay their annual or monthly or weekly subscription fees to that server company. So I think that's why that server company is keeping up the server stock. We're not going to lock it down, because I think they realize the magnitude of this thing. This is just not a South African based scheme, but it's a global scheme. And I think they're very cautious currently in that country. And if that country is regulation in terms of cybersecurity and cyber law is at the top in the world. So I think they're just hanging back and to see what's going on. But for now, let's hope everything goes according to plan.
Okay. All right. William, you upset the group every time. Have you got some more questions?
I think I would like, thanks, Chris. I think I would like to give especially Sharon an opportunity. I think we've really neglected her.
All right.
Thank you, Chris.
Sharon, you've got the floor. Go. You're the most, you're the most beautiful one here today, don't you?
Thank you. I accept that gracefully. I just do have a couple of questions on behalf of other MTI investors. I think it's just important, and a lot of the questions have been answered. William, thank you. You took one of the questions away from me. But regarding the sequestration, and then covered it, mentioning, that certain things can be attached by, certain MTI management / etc., etc. Once this video that is being recorded right now goes viral, do you not think it's going to give the opportunity of the folks who you are perhaps looking at, because I don't know who all they are, opportunity to hide their Bitcoin, hide their assets, change names, etc., etc.? I mean, does this not give them heads up?
They can try and hide away. I think with Advocate Vaughan Victor and the other guys, the cybersecurity and the legal enforcement and everybody that's at the back that's just waiting for this. If they try and move it, it's again collusion. They're breaking the law. it's more criminal cases against them. So if I was them, I would just work with the liquidators, or else they're going to have a lot of problems. There's a lot of criminal stuff in terms of the Companies Act and other banking acts that they obviously broke.
Okay, thank you for
So
answering
it's
that.
better for them to work with the liquidators. Yeah. And that's fine.
Okay. My next question would be, a lot of people have opened a MTI account in a business name, not just in their children's name or their mom's name. They've actually opened it in their company name. How would that affect any of this documentation we're sending in, or is it the same? Fill out the company name, sign it, and that.
It will be the same. So it will just say company XYZ, the details of the company underneath director, and they can just sign it. There's normally a block or something where they must put a stamp. If they don't have a stamp, they can just write in no stamp and just initial there. And then it's fine. It's just when you get big companies, let's say like one of the banks, for example, but which is not applicable here. They obviously have 10 people who are authorized to sign the documents. But with a normal company, if let's say we three and I sign it, it's fine. There's not a problem with that.
Okay, thank you. Another question that's come up by many of the investors is a question about Johan being CEO. I mean, where is he? Has he been found? Are we looking at him? Has the liquidation sort of gone a different course that nobody's looking for Johan anymore because they've invested all their life savings? A lot of elderly people have taken the entire pension and put it into MTI. Others have stopped working and just done MTI as a full-time career. So they kind of want to know, what does the liquidation pathway take them compared to looking for Johan Steinberg? So if you have any clarity on that, it would also help the investors.
Well, obviously the first part I would do is for the immediate sequestration of Johan, freeze all his bank accounts, everything that he has that we can get our hands on. And then from there on, work with some of the state agencies, law enforcement overseas. I think if you really want to, you can track and trace the flights, where he was, where he currently is. And from there on, they will get him. And then they must just obviously extradite him to South Africa. But I mean, he's got a problem. He's got a lot of stuff here. So you can only hide away so long. But even if you hide away, the other people will talk. So if they don't talk, they've got a problem. They're looking at jail time. So it's either they tell us straight what's going on, what went on, who was the masterminds, everything, or else they part and parcel of this. So that Johan will come out later. In any event, was same as the other cases. In any event, sometimes they do pop up somewhere. But I think there's enough people that he scammed that already maybe paid people to go and look for him. It's the messages that I read. So yeah, I think he would be fine.
Sharon, anything else?
That's all, Chris. Thank you so much.
Okay. I see Henry's joined us. I think he's got his internet sorted out. Henry, have you got a specific question? We're just wrapping up at the moment. Henry, your mic is still off.
Hi guys, can you hear me?
Yeah, that's good.
I'm very sorry that I came in so late into this meeting, and I'm just trying to follow the train of thought and where you guys have gone with this. So at this point, I don't want to maybe ask something or add something that's already been mentioned. If we have more time and you want to carry on a bit, if someone wants to give maybe just a short summary, Chris, if you want to maybe fill me in so I can maybe get in on a proper question.
Okay, I think I think the team have really covered this thoroughly at this stage of the game. I'll do a summary, and this is a pre-meeting because we do want to discuss further points and create questions for tomorrow when we are with Advocate Tuabi Bernardi. So we need to do just to follow on there, specific maybe from a legal point of view. So where we are at the moment is the provisional liquidation has been approved. We are in that phase of starting the whole process of recovering assets, there is an opportunity for the people who have the assets to come to the floor and to come and say, here we are, guys. And that's the least cost for everybody. That will be the kindest thing you can do to everyone, is to pitch up there and take the meeting and get on with it. And then you can either say, look, we've got enough, we can still trade, here's my trading vehicle, we can take it out of liquidation, and you can carry on and do whatever is done, as long as you then register yourself legally and get everything done properly. I think at this stage, we have two time constraints that have to be thought of. We need the appointment of a proper and a knowledgeable liquidator. We have approximately 48 hours as of now. Is that correct? As of this evening, or has the 48 hours already runs in?
Yeah, it started running already. As soon as the master receives the court order that the company's been put in provisional liquidation, that 48 hours starts running. So I'm not sure. Vaughan can actually tell us if our advocate has lodged it with the master already, then that would have started running that 48 hours already. So it's already started, I believe.
Then it will be lodged tomorrow morning. So the 48 hours will be started tomorrow morning.
Okay, so when is our 48 hours?
Okay, let me rephrase. Sorry. The order was lodged this afternoon. So the 48 hours started at around 3 o'clock this afternoon. So Thursday, 3 o'clock. On Thursday, 3 o'clock. So appointment will probably be made on Friday morning.
Yeah.
Okay. So
Chris, it will depend on the administration lying ahead of the master. Imagine there's 500 or 600,000 requisitions lying there. It's very improbable that they will finish that all in a couple of hours. So it might even, if it's so many, it might even stand over till Monday. But we will force the master to try and make an appointment, because we need to act. So I think it's up to our legal team also to address the master and say, make a provisional appointment of one of the on-site value, what is on the table, so that we can start acting. We don't want to wait another 3-4 days.
Yeah, and then maybe the other guys can fall in later. And just another point that's come out of this, you have not lost your investment if you don't get your form in, but you should take part in the voting system in your own reality. Do some homework and take part in the voting system to get the right liquidator appointed. And then I think that sort of wraps it up. And the other thing is, don't despair. We have good people who know what they are doing. And if we all choose the right people to do this, then this doesn't need to cost us thousands of pounds to get resolved. And you don't need to run to a whole bunch of solicitors and pay people to do this. The system is already in place. Am I right, Zen? Is that correct?
That's right, Chris. The liquidators have to have enough cash flow and money available to drive this. And that's what makes them a special organization. They must have the cash flow to drive this, pay attorneys upfront, and go so forth. Some of the guys even have a slush fund for cases like this, and some have backup from people that will actually finance something like this and get their money back a little bit later. And the liquidator will have to pay out of his fees that he earns, will have to pay the finance cost of that. So it is a costly affair, and especially when we're going to go cross border, when we have to brief some other foreign attorneys and solicitors, that might cost a lot of money. But the big thing is that we need the liquidators going to act swiftly, quickly, and without being scared of nobody.
Hendrik, is that about it? Are we pretty much on course? Do you think we're fine, Hendrik?
Sorry, I just there for 1 second. Chris?
Yeah.
Just ask a question, please. I must you there for a second.
No, I'm saying that have I sort of covered the main points? Is there anybody? I'll just go through the panel quickly. We'll just go through. Zen, do you feel there's anything else we should add to this? Just this where we are at the moment, Hendrik?
I'm happy so far with what you've covered. I'd just like to emphasize it again to everyone out there. Make sure that you know the history of the liquidator that get appointed. I've seen in some cases that liquidators get appointed who has been discredited in court proceedings previously. And such a person, one can doubt that such a person will be working in the best interest of the investors.
Okay.
Thank you, Chris.
Okay, Christopher, have you got anything else you'd like to add?
Yes, it's just very important, like the other colleagues of mine said, get the 2 best liquidators, vote for them, and they will have your backing. They will be there for you. And I promise you, the team that's already there is well experienced and well equipped to do this. So as soon as the members can just complete the nomination form, no cost to them, just get the correct liquidator appointed, and then from there on, everything will flow. So
Zen?
looking forward to working with them.
Zen?
Yeah, what my learned advocate said is true, and the liquidator Christopher said is true. From my years of experience, and I'm sorry to say this, but with everybody on this panel, I'm the most experienced, unfortunately. I've been doing this for 25 years. And I've come out of the old era and I'm in the new era now. And in the old days, there was a paper trail. There was bank accounts, there was a paper trail, it was easy. Now we're dealing with cryptocurrency wallets, it's not so easy. So if you're going to choose the long liquidator, you're going to choose the wrong team, you're going to end up with misfortune and crying at the end of the day. So don't make that mistake. Be alert, be wake up, do your research. You've still got 48 hours. I wouldn't say 48 hours, you've got 24 hours, then you must start doing your paperwork to get your liquidator appointed. But be careful. Read up on their websites, see who's got who's already been through the school of the Ponzi schemes, who's been through the school of the cryptocurrency. That's your man, that's a person you back.
Sharon, you had your hand up.
Can you just please confirm where we get that nomination form from for all the MTI investors to know?
I think that the best person to answer that is probably Christopher. Christopher, can you answer that? Generally, where would that form be available from?
Generally, I've seen on the groups, there was post of the nomination forms. I don't know if I must mention liquidators' names or the firms that they can go and download it, or if they want to on the RAG group, they can just maybe give their email addresses and that can be sent out and they can then reply to that. So, but I see most of the groups on Telegram. I've posted on Facebook, on Telegram, on all the other groups, Twitter, LinkedIn, everywhere I posted my documents. So if they want to, there's an example on, they can just Google Savenza Trust or Liquidation Experts. That's one of the firms, and Invest Trust. Their documents are also on there. So I've seen their nomination forms with an example. Everything is there.
Thank you.
Anything else there, Sharon?
That's all. Thank you so much.
Tace? Tace, have you got anything? Oh, Tace looks like he's frozen. William, have you got anything there?
No, I'm good. Thank you.
Tace, are you back with us? Okay, good. Henry, would you like to add anything? I've still got Vaughan. Vaughan still, Farmer Brown still needs to come in just in the end there.
Chris, yeah, I wish I was a little bit more in time for this meeting. It would have been good, but I don't want to fill in anything that I don't really understand that's been covered exactly. So I'm good for now, and we will talk after this.
Okay.
Okay, I'm fine.
Okay. Advocate Vaughan Victor, have you got anything, sir?
No, I'm good.
Okay, so Hendrik, is that it? Are we good?
Yes, thank you very much for this opportunity to clarify a lot of questions that I know many of the investors have, specifically pertaining to the liquidation process, and as well as what will happen or might happen once the order of court is made, a final order of court, if it is not, if the people don't come to the party before that. Thank you, Chris. It's much appreciated.
I have one thing. Yeah. I have one thing. I just wanted to understand, this was just a pre-preparation for the YouTube video that we are planning to actually cover.
Correct. What we did here is give the basics, the groundwork, and then tomorrow we'll field the fully legal questions and anything that flows from here that we haven't thought of. But it's important for people to maybe get a preview of this so that they can know what the basics are. And then tomorrow we've got Advocate Toby on the line as well, and he can give us more specific information to follow on with, so that we can know exactly what's going on. In the meantime, it also gives us in RAG an opportunity to really understand what's going on and to follow through with what we should say to investors as well, because we're also lost and we're being asked a lot of questions at the moment. So it's really important for us to also be able to answer some of those basic questions. Okay, guys, I really want to thank you. This has been very informative. I really appreciate the way the panel has dealt with this, and I really appreciate your time that you've put into it. This has been an amazing opportunity, and I think there are a tremendous amount of investors out there that will find this extremely valuable. Thank you so much for that. Thank you, gentlemen.
Thank you very much.
Thank you.
Thank you.
Thanks, guys.
Bye.
Thank you.